Good afternoon yet again, folks. You're watching the Law and Crime Network. We are in the midst of the George Burch trial out of Green Bay, Wisconsin. A young mother named Nicole Vanderhayden was found dead in that case. We're going to break out of the testimony because things are moving rather slowly now with some photos that are showing things that were looked into but that didn't yield very many clues. We're going to keep an eye on the trial, though, and when things start to pick up again, we'll bring you back there live. If you'd like to keep watching it, though, you can always go to our dedicated feed on lawandcrime.com, click on the live tab, and take a look at the various trials that we are covering at any given time. In the meantime, Andell Brown is an attorney in Florida. He's joining us now here on the Law and Crime Network. Andell, good to see you again. Want to talk about this case a little bit. You've got a lot of finger pointing going on here, and the evidence is seeming to slow down a little bit, but perhaps the first of two possible high points in this case came and went last week with the boyfriend and the father of the victim's child on the stand, basically saying that he had nothing to do with her injuries or her disappearance or her death. And yet you have all these rancorous text messages back and forth between the victim and that same boyfriend who denied involvement the night that this whole thing went down. So the cross-examination of that particular boyfriend to me seemed very, very weak. It got at a couple of issues, but it wasn't very jarring. Did the defense need to take that guy down a little bit further, or is it the classic case of a defense attorney not wanting to ask too many questions because it's clear that the guy already denied involvement and he's not, of course, going to break down on the stand? That only happens in the movies. What do you think?
Well, I think, Aaron, the defense may have not taken advantage of the opportunity to really go at him. He's the prosecution's star witness. This case rises or falls on his testimony. And when you get him on the stand for cross-examination, you got to take control and you got to go in there and make him uncomfortable. You got to make him look like he's not credible. You got to make him look like he has something to hide, because that's the only thing that's going to save your client.
I agree. I thought that the cross-examination could have been stronger. And look, I realize, as I said, and you certainly realize that as well, that witnesses don't crack on the stand and then admit they've been lying all along. Even if they have been, they tend to stick to their story. The only real way you can go at them is to go at them with pieces of information that you have at your disposal. And here there were things like the text messages. There were other pieces of information that were already on the record that the defense had, but I don't think that they really, tightened the noose around that boyfriend and forced him to basically admit to the existence of this stuff as well as they could.
Yeah, I think those text messages, as well as the testimony of his friend Greg, who was with him on that night, made it seem like it was a lot more contentious than he was trying to let on. It made it seem like they were having arguments, that they were really in conflict, going back and forth with each other, and it seemed like the defense let him off the hook when it was time to get on the stand. I thought they really were going to get into how volatile that relationship was and get him to admit or at least impeach him with some of those records to show that the perfect picture that he's painting, the calm picture, the fact that he laughed all of these things off, just isn't accurate.
Yeah, and just to let people who are watching at home know, it looks like they're taking a break in the trial right now, so you're not really missing too much. Andell, let's kind of keep going with this here. If you were leading that cross-examination, were there any questions that jumped out in your mind that you think really should have been asked that were not asked?
Well, I think, Aaron, there were some questions that were asked, but when you're on cross-examination, number one, you want to keep control, but also number two, you want to lead that witness along, kind of like the breadcrumbs along the trail to where you ultimately want to go. When it came to having him on the stand, one of the things that I would have liked to have seen the defense do is make sure they drew out why exactly it took him so long to make a call to the police to report her missing at 4 o'clock the next day. She didn't come home. They had been looking for her. They hadn't found her. Why did he take so long to do that? I think that was one of the main questions you want to be able to draw out of him, or to have him not be able to give an answer to when he's on the stand.
So one thing that jumped out, that came out of that information from the boyfriend, the father of the victim's child, is this insinuation that she was, in his words, crazy at times.
Right.
That's one of those key words that my trial advocacy professor would teach me to just hammer and zone in on constantly. And it's sort of like the technique, and I'm sure that you use this, where you get a piece of information and then you keep backing the witness up to repeat those quote-worthy things. Well, you said that you were so sad, but you also said she was crazy, and it just keeps forcing the issue over and over again.
Right, and you know, he said that to his friend as well. His friend Greg testified that he said, "Oh, she's acting crazy, et cetera, et cetera." And it makes it seem like there's a lot more going on than he wants to let on. That should have been investigated more. They should have gotten into that. They should have made him explain what he means by that.
It was an interesting line. Apparently, this relationship was a bit rancorous. I mean, one could presume that based on the boyfriend's insinuation that sometimes the victim was acting crazy or would start acting crazy. You can infer it by the words the victim had for the boyfriend before she disappeared. We've heard the lengthy list of swear words over and over again. We also can infer it based on a few other things. You know, the boyfriend's friend, who is up there basically to bolster him, okay, says, well, I can see why some people might think that the boyfriend's a jerk. So, you know, do these people like one another or do they not? I don't know.
It's a tough one to call, Aaron. It seems like a lot of his friends weren't happy with his behavior. Even, I don't believe I remember the name of the lady that was with Nicole at the second place that they went to. When she finally got him on the phone because he wasn't answering Nicole's calls, she was like, "Where are you? What's going on?" She was obviously agitated at the way that he was treating Nicole on that night. Why wasn't she able to find him, and did she have to hang out with people she barely knew at a whole different spot because he's not answering his phone, he's not being available? It seems as if he abandoned her. And I think that's something that the defense should look into, because even if we look, Aaron, at the types of injuries that happen here, one of the arguments that you would want to have or introduce through an expert is that these types of injuries, the brutality and the attack, indicates more than just a desire to somehow kill or silence someone. There seems to be a bit of rage going on there. And who would have the motivation to have rage but someone who knows her, has a protracted relationship with her, and may be angry about the way things have progressed over time?
Good point. Let's take a break here and listen to some of the previous testimony in this case. We want to review some of the testimony of a detective from the Green Bay Police Department who was involved in this investigation. When we come back from this break, we are going to continue the conversation with Andell Brown. And also, Andell, get ready for it. I want to talk to you about a piece of information that came out from a friend of the defendants today that could be key to this case. If you're watching, again, this is the George Burch case out of Green Bay, Wisconsin. The judge has called about a 15-minute break. We'll bring you back to live testimony as soon as it resumes.
How about what time you arrived on that scene that day?
I want to say later afternoon.
And ultimately, did you receive direction about how you could assist?
Yeah.
And what were you assigned to do?
Myself and a deputy were asked to speak with Greg Matthew initially.
And who was the deputy that was with you?
Caters.
And where did did you ultimately speak with Mr. Matthew?
Yes.
And where did that take place?
At the Brown County Sheriff's Office.
Was Mr. Matthew under arrest?
No.
Did he speak with you voluntarily?
Yes.
About how long was your interview with Mr. Matthew?
I want to say probably an hour, maybe a little longer.
What was Mr. Matthew's demeanor during your interaction with him?
Very cooperative, very helpful, answered all of our questions freely.
And after speaking with Mr. Matthew, did you have an additional assignment?
Yeah. Later in the evening, we were asked to speak with Doug Dietrich.
Where did that take place?
Again, at the Sheriff's Office.
And in your interactions with Mr. Dietrich, did you have an opportunity to observe his demeanor?
I did, yes.
What was the nature of his demeanor?
Kind of two parts. Initially, he was always cooperative, spoke to us freely, answered our questions, offered whatever he could to help. Later in the interview, when we discussed the possibility of he had brought it up to us of a body being found, that it may be Nikki, then he became upset, cried, in my opinion, acted appropriately to that situation.
So when your interview started with Doug, about what time was that interview?
I think it was right around midnight.
Very late at night.
Yeah.
At that point in time, you knew that Doug was aware that a body had been found?
Yeah, it had gone across the news.
And at some point during your interview with Doug, you shared some information with him about the possibility that this might be Nicole?
Yes, towards the very last part of the interview.
What type of information did you share with him?
Well, he had asked a question because he was becoming more and more upset or anxious, wondering, because he up until that point we hadn't talked about a body being found. So he came out and asked us if can you tell me about this body that was found? Do you think it's her?
And what did you share with him that would have led him to believe that it might be Nicole?
Eventually we talked about the similarities from what I knew of the body that had been found and things that he had told us about Nikki, hair color, general description, a belly button piercing, and I left it with him that I couldn't say for 100% certainty that it was her, but there were similarities.
What was his reaction to that information?
He broke down and cried, and again, I acted what I would consider to be appropriately.
Did you ask Doug for any items of evidentiary value that night?
Yes, we collected his, in the interview we asked him what he had been wearing the night before when they went out, and he stated that the shoes and jeans that he was currently wearing in the interview room were the same ones that he had on the night before. So we collected his shoes and jeans.
Welcome back. We continue to cover the George Burch murder trial out of Green Bay, Wisconsin. This is a first-degree intentional homicide case related to the death of a young mother named Nicole Vanderhayden. Andell Brown is an attorney in Miami. He remains on the line with us here at the Law and Crime Network. Andell, a key piece of information may have come out of the case this morning that might really help the defense as it plods along here. Here's the thing. One of the friends of the defendant said that the defendant was watching TV, saw a report about this victim's death on one of the local TV stations in Green Bay, Wisconsin when it happened, and basically didn't say too much about it, which is a little bit bizarre. But then the friend also said that his friend didn't have any injuries. No scratches, no nothing like that would have been visible. And it would seem to me, again, that that's a golden nugget that the defense is going to have to really latch onto and argue. That, hey, look, if he had basically taken this woman, somehow killed her somewhere, presumably she would have tried to fight him off in some way and left at least a scratch. But there was nothing right after this thing happened. So, you know, is it a case where the defense really needs to grab onto that? Or if the defense does grab onto it, is it going to leave the defense open to an attack by the prosecution? Well, of course the friend would say that.
Right. I think you hit the nail right on the head, Aaron. They're a friend. You know their testimony is more than likely going to be sympathetic to their friend. And when you make the argument that there was not a scratch on him, it's not something that you can show the jury. You can't show the jury a picture of what he looked like that day. And it's not only the fact that they're a friend, we're left up to their perception. They didn't really examine his body. They probably just looked at him like you look at anyone else in the room, give them a cursory glance and move on. The other issue is going to be the DNA. The DNA that was found under Nicole Vanderhayden's fingernails and other places tell a different story. It tells the story that there was some type of struggle. Why is his DNA under her fingernails if there was never any type of struggle? Where that scratch was, we don't know. Was it in a place where the friend could have seen it? We don't know that either, but I think the prosecution, if they have to rebut that evidence, that's how they're going to come back. They're going to come back and say and explain that, number one, they may not have perceived it. Number two, they may be covering for their friend. And number three, the DNA tells us a different story.
You know, look, here's the thing, though. The defendant has got this. If you don't believe him, it's a convenient story. If you do believe him, it's an extremely convenient story that this whole thing was some kind of a consensual sex act, and that's how it started. So does that explain DNA? Does that explain all the DNA? Or does it just sound so preposterous that it just doesn't even work? I mean, I guess if that was the only story, maybe we could take the evidence in totality and say, okay, look, she was having a bad fight with her current boyfriend. He apparently seems, at least in her mind, to have ditched her and spent a lot of time with some other women. Maybe she ditched him to go into the arms of another man that night. Maybe that explains some of it. But then once you go from there, is anybody going to buy this defendant's story that it was the boyfriend who did the killing and forced the defendant to then go along with the cover-up?
Well, Aaron, in a vacuum, the defendant's story, it makes sense in a vacuum. If you just say, hey, would it make sense that a boyfriend, if he found his girlfriend with another man having sex outside of their home, would he be angry? Could that drive him to rage? Could that drive him to murder? Absolutely. However, when you look at the total picture and you start looking at the time frames where things happen, you look at the way things unfolded as far as when George Burch was at the bar, as far as when he moved from that location to another location, as they tracked him through the Google data, I think it tells a story that's more consistent with the prosecution's argument, and it kind of makes his whole, the boyfriend got me at gunpoint, took me, made me do all of this stuff with the body, it kind of flies in the face of that. The fact that you have the Fitbit data that says the boyfriend was at home at the time, or he didn't move, he didn't take all of these steps, et cetera, I think it makes the defendant's story fall apart. In a vacuum, yeah, it kind of makes sense, but once you look at the entire story, you look at the time frame, you look at when things happen, I think the prosecution's case looks a lot better and the defendant's story looks a lot worse.
Yeah, to remind everyone, we're in the midst of about a 15-minute break here. Andell, I agree with you. I think that's the sticking point here. So, look, again, this is a case involving a young mother, Nicole Vanderheiden. There she is. She's the victim in this case, was found dead not terribly far from her home in the Green Bay area. This all happened in the Ledgeview area, which is on the southeast side of the city of Green Bay. It's an area where there is indeed a ledge that provides a view where one can look across at the Bay of Green Bay. And it's a pretty new area, a relatively up-and-coming area, a lot of new construction. So the images of the homes that we're seeing in that area, not much of a surprise. Andell, I want you to listen to a little bit of the testimony of a neighbor who, right after this woman disappeared, wound up finding what appeared to be blood, wire, and hairpins in the area of that victim's home. Let's listen to some of his testimony now.
Exhibit, yours is in the furthest to the bottom and left, is that correct?
Correct.
And are you also familiar with a neighbor of yours, Douglas Dietrich?
Yes.
And you're familiar with where that gentleman lives? Is that also depicted in this photograph?
Correct.
For the record, you're pointing at the top leftmost residence, is that correct?
Yes.
Thank you. Have a seat. Directing your attention to May 21st of 2016. Do you recall that day?
Yes, I do.
And what about that day sticks out to you?
I went out to mow my lawn at about 10 in the morning and came upon an area in front of my yard that was had a significant amount of blood.
And where was this area specifically?
It was abutting the curb at the very, very front of the yard, almost directly in front of my home.
Do you want him to show that on the photograph? Why don't we put the photograph back on the big screen and he can point that out with the pointer?
approximately here.
It's approximately in the middle of the photograph to the left edge at the grass line and the curb. Is that correct?
Correct.
Okay. And at that point, did you locate anything else in your yard?
Not immediately. I did proceed to begin mowing my lawn, and in the very first pass of mowing my lawn close to the curb, I heard a click. It was sounded like my blade of my lawnmower hitting something, and I shut my lawnmower off and found a piece of cord that I picked up and examined and then set aside.
Mr. Peterson, I'm showing you two exhibits marked 65 and 66. Could you identify each of those documents for us?
65 is a view from the street of my yard, including the portion of the curb that still has blood stains and a piece of cord. And Exhibit 66 is a close-up view of some of those blood spots on the curb and a piece of cord.
Do both of those exhibits appear to be fair and accurate depictions of the observations you made on May 21st of 2016?
Yes, they do.
I move to admit exhibits 65 and 66 at this time.
Subject to cross, any objection to 65 and 66 being received?
No objection.
65 and 66 are received.
And permission to publish, Your Honor.
They can be published on the big screen.
Mr. Peterson, we're looking at exhibit 65, is that correct?
Yes.
And you stated earlier you located the wire in your yard, correct?
Correct.
Could you, do you recall where approximately you came across the wire?
I do recall approximately where.
And could you point out in the exhibit approximately where that was? For the record, you're pointing towards the middle of the photograph a little bit above the curb, is that correct?
Correct.
And do you recall approximately how far away you were from the curb at that time?
I'm guessing approximately 1 foot.
Okay. You can have a seat, thank you.
So, Andell, there we have some testimony from one of the neighbors in the area of the victim's home saying that he was out and that he all of a sudden discovered what appeared to be blood, these pieces of wire, hairpins. What does this mean? Does this mean that this is where she was taken?
It appears to indicate that either that's where she was taken or that's where some type of struggle occurred. And, you know, that's always been one of those facts, Aaron, that I looked at and kind of tried to figure out where do I place it. If I was the defense, I would be arguing if this man has bad intentions, George Burch, if he has bad intentions, why would he take her to her home and then attack her there? I mean, he has control of her. She's in his vehicle. I'm presuming he can go anywhere. Why would he take her there? I think if I was the defense, I would argue that what happened was that that's the boyfriend that made that the crime scene. That's why you have the blood there. That's why you have the wire and the DNA there. That's why that was the particular place where it looks like either some type of attack happened, the struggle, or ultimately the murder occurred.
Yeah, I'm wondering exactly how this all fits in the puzzle. Maybe the prosecution tried to tie it together and it just didn't click with me. But it looks like we're probably going to be back very, very quickly from this 15-minute break that the judge had called. I'm hoping that we're going to be able to go back to the courtroom very soon. We do. So let's go back now. Andell, good to talk with you about this case. We'll probably check in with you in a second. Let's go back to the George Burch first-degree intentional homicide case in Green Bay, Wisconsin. Getting ready for cross-examination here of a witness who was one of the investigators who took some tissues for analysis. Now, Andell, this seems like a no stone unturned investigation. One of the things they collected was what appeared to have been an industrial sort of paper towel, like you would see at a restaurant or a bar or a gas station bathroom, and they found it in a local park. And they sent that in for analysis. So they're looking at everything they can get their hands on here.
Absolutely, Aaron. And I think what that does is it helps bolster the prosecution's case that these cops were going wherever the evidence led them. At first, it led them in one direction, but as they continued the investigation and left no stone unturned, as you said, it led them to Burch. It wasn't a jump to a conclusion. This is what the evidence says. They have a strong basis for it. They have DNA and other circumstantial evidence that leads them to this point. And I think that's why the prosecution has taken such great, deep time to lay out in detail the path from the beginning of the incident to Burch being the person that they found to him being guilty.
Yeah, if there was a leap to judgment here, it was arresting the boyfriend before a lot of the other evidence came back. Now, one could say, hey, look, if you're suspecting someone of first-degree intentional homicide, you want to prevent the person from fleeing or at least try to do something, but they ultimately had to let him go.
And I think that inures to the credibility of the police department because they were willing to say when they made a mistake. And I think some people, we've seen investigations where it appears that once they focus on a specific person, they do not necessarily want to take into account evidence that it's not this person, it's someone else.
Two questions. So you talked about being very fair.
And let's cut back to court. We've got cross-examination beginning.
When you're driving north, can you see Bellevue Road from that intersection?
When you're driving north on Bellevue Road, can you see?
When you're driving north on GV,
okay,
and you're at the intersection of GV and Hoffman Road,
okay,
can you see Bellevue Street?
No.
And that's when you're traveling north?
Correct.
And what about when you're traveling south? Because you have a different view.
No, it would be blocked by the development and then the sheriff's department, their hotel. There's a lot of businesses in there.
Okay, thank you.
Anything else? All right, for now, to take a swing, you may step down again. State's next witness. Sure.
We're going to cut back in now. We've got another witness about to take the stand any minute. One thing I should mention to folks, we keep hearing references to GV. If you're not from Wisconsin or haven't lived there or traveled there, this is another one of these quirks of the state. Many county highways are given a letter or a series of letter designation. GV is one of the major trunk highways that sort of rims the Ledgeview area where this thing happened. It goes straight north-south, right on the compass bearing. And keep in mind, in Wisconsin, these letters don't really line up. So GV does not intersect with G or V necessarily. They are just arbitrarily assigned, and it gets a little bit confusing because that's just the way it is. But Andell just wanted to point that out to you. Not sure if you knew that. I had to give a bit of a geography lesson today.
I did not know that at all. I would have been terribly lost without you, Aaron.
Well, you know, I have driven that road many a times. It's been a long time, but when I lived up there 10 years ago, I was on that road not infrequently. So we're getting bits and pieces of this investigation now just kind of being put onto the record, even though from my perspective, they don't tie together a really clear narrative. It almost looks like we're just throwing everything into the sink, hoping that it turns into something.
Yeah, it sounds a lot like the kitchen sink theory that's going on here. We're going to put everything out there, and we're going to take whatever we find useful as it comes out. I don't find that to be the best way to proceed with trial because jurors, they have a lot going on. Let's just be honest. Most people's attention spans aren't that great. They want you to get to the point. Whatever it is you got to show them, they want you to make sure you present it. And they want you to lead them down the path. They don't ever want to feel like you're wasting their time or you're just asking unnecessary questions. I think even on the defense side, when they were questioning the forensic expert, it seemed as if no one knew where they were going with their questions and how that even applied to their case, because we're talking about what's inside the house, not what's outside the house. So jurors, just like the rest of us, appreciate lawyers that get to the point.
You know, oftentimes we see discrepancies in this depending on just how much pretrial preparation an individual state allows. I realize the trend is towards turning more and more and more over to the defense before trial, but in some states, the defense has to ask a lot of really open-ended questions because they don't get a lot of information before trial. It looks like the judge is back on the bench speaking, so let's cut back to the George Burch trial.
Case with anyone, and again, avoid reading anything about the case. Thank you very much.
All rise.
And it looks like what we may have missed while we were in the midst of that discussion about preparation and whatnot, that they may have made a decision to wrap up for the day. This looks like the all-rise session when the members of the jury basically get to go home. And I'm getting a note from our senior trial producer, Kathy Russin, that yes, that is indeed where this is. And yes, Andell, the state has rested. Excuse me, I'm reading part of a message and not the whole thing. The state will rest tomorrow after 2 more witnesses. And one thing we can't bring to you folks watching at home or wherever you happen to be watching is what's going on as far as evidence wrangling outside the presence of the jury. The judge is not allowing us to stream that. And that's kind of an interesting move because when I was in Wisconsin, we tended to be able to show almost everything. And perhaps this is a move that was a result of trying to limit how much of this gets disseminated publicly, although the court documents generally are public. But there's been a lot of evidence motion practice in this case, Andell. So just to talk about that generally, of course, we know that heading into trial, you get a chance to file motions in limine. They tend to be used very frequently in Wisconsin, I think more so than in many other states, trying to get evidence into the case that an attorney wants to have and to keep evidence out of a case that an attorney doesn't want to have. And that's exactly how this whole debate over the Fitbit data erupted. That was all taken care of before trial, but we have had other evidentiary issues that have come up on an almost daily basis here that seem to be pretty big things. But we can't listen to the argument, so we don't get into the details. But the Fitbit data, Andell, trying to prove that the boyfriend was at home sleeping when the defendant claims that he was involved in this crime, we know that the data is coming in except for the sleep data because the judge found that the data is generally reliable, but because the sleep data is contested, and has been contested in other cases, which the judge thoroughly outlined, that the sleep data doesn't get to come in.
Right, Aaron. I think you hit the nail on the head in the sense that the sleep data has not been found to be reliable to actually say within a possible degree of certainty whether someone is asleep or not at that time. However, the GPS data and the steps that the person is taking, whether they're in one location or not, has been found to be dependable in case after case as outlined in the judge's decision. So that is an important piece of evidence because it totally eviscerates the defense's theory that Dietrich was with Burch, going at gunpoint, having him dispose of the body after he killed Nicole Vanderheiden. Yes,
so a lot of evidence practice here. In this case, the judge wanting to kind of keep it from being hashed in a way that perhaps an unscrupulous juror could, could in fact perhaps listen to it if the jurors aren't paying attention to the instructions, which would be bad. But we're going to try to keep an eye on what's going on with that. We can't stream it, but we can discuss it. We can report on it. So while we try to keep a handle on what's going on, a reminder, folks, that court has wrapped up for the day. The jury has been sent home. The state has 2 more witnesses, after which the state will rest its case tomorrow. In the meantime, let's continue reviewing some of the testimony from the neighbor. We started to bring you his testimony before during a 15-minute break that happened maybe about half an hour ago. But this neighbor found what appeared to be blood, hairpins, and some wire. I think it was when he was mowing the lawn. So let's continue to review his testimony. We'll be back with more analysis in a moment.
And did you know Nicole Vanderheiden?
I had waved to her from across the street numerous times. I don't know that I ever formally met her.
Well, were you familiar she lived across the street?
Yes.
And at that point, you reported your observations to law enforcement?
Correct.
Since May 21st at about 10 a.m. when you first observed the blood in the cord to the time that you reported it, did the blood or the area with blood change in any substantial way?
I did mow my lawn through the area, and I know that resulted in some change. I know that some of the blood dried and browned a little bit, so there was a little bit different appearance. Otherwise, the area remained virtually unchanged.
And when you ultimately did report your observations to law enforcement, did officers arrive?
Yes, officers arrived at my home about the same time I did.
I have no further questions.
Cross-examination.
Can I ask that the exhibit of the overview house be placed up, exhibit 64?
All right, we'll have 64 published on the big screen.
Mr. Peterson, that's an overview of your basic neighborhood, am I right?
Correct.
And can you point out where your house is? Can you point out where the Dietrich house is? And thank you. Go ahead and have a seat. Now, you say this cord was found right out in front of your house, basically, right?
Correct.
And the reason it came to your attention is because you were mowing the lawn and you heard a click.
Correct.
And so you pulled the cord out and you kind of looked at it, right?
Mm-hmm.
You touched it, looked at it, and put it on the street, right?
Correct.
And the purpose for that was so that you didn't run over it again.
Absolutely, yes.
And then you just finished your lawn.
Yes.
So it wasn't until the next, well, I'm sorry. Now, you were mowing your lawn on what day?
Saturday, May 21st.
And so 2 days later, on the 23rd, is when your wife called you?
Correct.
And your wife calls you because now she's watching the news, right?
I don't recall if she saw it on TV or heard it from social media. I don't recall where she heard it.
And so you guys were discussing what you had seen, right?
Correct.
And so you thought, boy, this may be some evidence to this case, right?
We thought that it was possibly evidence related to the case, but we were not sure.
So then you called the police and had them photograph and look at the scene, right?
Correct.
And as the police is there, you're starting to think back of suspicious things that you'd seen, aren't you? Isn't that true?
I was racking my brain to think of anything that had happened in the last 48 to 72 hours that I could think of.
And you told the police that you'd seen a smaller car in front of the Dietrich home, am I right?
Yes.
What did you observe about that car?
I believe it was the afternoon of Saturday the 21st. I just noted a small car that that drove very, very slowly past my home and the Dietrich home. And I believe drove from west to east. And I saw the driver talking on his phone, but looking at the Dietrich home, and then turned around and drove back east to west and pulled into the Dietrich driveway. And I don't recall that he ever got out of the car. The driver got out of the car, but was just on his phone the whole time. And it was just a slightly notable occurrence that I thought about as the police asked me if I had seen anything unusual.
Reviewing testimony there from a neighbor who was out mowing his lawn and hit a patch of grass where it turned out there was what appeared to be blood, hairpins, and wires. We are presuming that that may have been an area where the victim, Nicole Vanderheyden, was attacked. Andell Brown, attorney in Miami, Florida, remains on the line here on the Law and Crime Network. Andell, one interesting little fact that we know that the jury will not hear is the fact that this defendant was tried for murder about 20 years ago in Virginia and was acquitted. Now, you and I know the answer to this, but I just want to explain it to the audience. That stuff doesn't come into this trial.
Absolutely. It does not, Aaron. Obviously, unless there's some common scheme or some special method that he used there that will apply here, it's not going to come in because the probative value is extremely low and the prejudice to him having a fair trial here is extremely high. He was found not guilty. He wasn't convicted. It's not going to come in here.
Exactly. So, but still, it raises an interesting question. Does bad luck follow this guy around, or does he just get himself into sticky situations?
Yeah, I mean, for us that are looking at that information, you begin to wonder, is this the type of guy that's done this sort of thing before? He feels like he can get away with it, and he knows what steps to take, or he's tried to take steps to cover his tracks. Those are great questions to ask. Also, you want to know, is this guy like trying to work the system? He's trying to manipulate the prosecution to make sure he gets off again. But in reality, from the legal sense, we really don't know. People get accused of crimes for various reasons, and sometimes the reason is that they get acquitted or found not guilty is really that they had nothing to do with it.
One interesting thing here, too, that I want to mention is in Wisconsin, the charge is first-degree intentional homicide. That's the top charge in the state. It does not require an element of premeditation, which I think that your top charges in Florida require, correct?
Absolutely. Their definition of murder is first-degree murder is very simple. It really is just any time someone is killed and it appears that the actions you took were intended to kill that person, that's it.
Yeah, that's life in prison in Wisconsin. It's relatively easy to get a conviction, and it's why when I was covering trials up there, why it wasn't a surprise that there was a conviction on the top charge so frequently, because the top charge was relatively easy to prove by comparison with the way it's written in other states. If you didn't have to worry about that premeditation element in Florida, gosh, it would make your job as a defense attorney a lot harder, I would think.
I think so, but I have to admit, Aaron, I think it's best to have these different degrees and nuances in the murder charge, because someone who kills in a fit of passion or by negligence probably should not be lumped in with the same with someone who premeditates, plans, and carries out a murder of someone else. And I think in a state like Florida, where you have the death penalty as an option, you want to make sure all the elements are satisfied that this is the most heinous, the most gruesome type of murder where you have the highest penalty involved.
I would agree with that analysis as well. We are going to move on and listen to another clip, though. The judge is still going over some what I presume to be motions practice here. We can't stream it, but that's what's going on in the courtroom. The jury went home for the day, and the George Burch case to resume tomorrow. The state has 2 more witnesses left, and then we expect the state to rest its case in chief. The state seems to be winding down here. We've just had some people collecting what seems to be extraneous data from the crime scene here. And possibly looking at other surrounding items that were in the vicinity of the area called Ledgeview where this happened, including this tissue that was found in a park. Is it going to yield some critical piece of evidence? We don't know yet, but they were looking literally everywhere trying to figure out exactly who did what in this case, and I think the prosecutor is trying to get that across. But while we march along here this afternoon without the jury present in court, we're going to continue reviewing some of the previous testimony. This is more testimony from one of the neighbors who lived in the area where the victim and her boyfriend also lived.
And you being aware of when he came home, that corroborates the timing.
Correct, yes, because I distinctly remember thinking, they must have given the time and the transportation time allotted. I thought, they made it till 5:30. They didn't quite make it like they were bragging they would make it till 6.
Okay. So did you contact anyone when you realized you had footage of the Berkeley Street?
Yes, we called the non-emergency number for, I believe it was the county. And
was that also on May 25th?
Yes.
It's the same time?
That night, yep.
Did they come out right away?
What happened was I called them, and whomever we spoke with, we said that we would put it on a flash drive and that they were going to come to my husband's work the next day and retrieve it. And then when we hung up, it was maybe 15 minutes later when they called back and said, we're going to send someone tonight. And then they came over maybe it was a half hour later. So maybe it was 10:30-ish when someone came to retrieve it and take the statement.
Okay. And they took a statement from your son, is that correct?
Correct.
But you all talked to them and...
Correct, yeah, we were all there. Yes, my husband and my 2 children and I were there.
And then your family actually then provided that flash drive with the video to the sheriff's department?
Correct, yeah, we handed it over to that officer, yes.
I don't have any further questions, thank you.
Okay.
Any cross-examination?
No, thank you, Judge.
Jones, thank you.
So
Ms.
again,
McDowell.
testimony from neighbors talking about dash cam footage, talking about things that they found in the neighborhood that may have played a key piece in this investigation. Blood found in the area of the victim's home, hairpins, wire. It got caught up in a lawnmower from what we've heard from a number of the neighbors, and it was analyzed by the police. That testimony went on for quite a while with the evidence collection technicians, but we're getting some information coming out of the evidence hearing that's going on in court right now in this case. The judge allows us to stream and televise what's happening when the jury is present, but not what happens outside the presence of the jury. We can, however, report on it, and a couple of big decisions have just been made. And Andell, I want to talk to you about these. One, the role of technology in this case just keeps increasing and increasing. More information that the state wants to get in. Testimony about and data from a device in the victim's car from the insurance company that captures how the vehicle's driving and presumably how many miles are on it, things like that. So again, does it prove exactly how far the victim went that night? Did she go all the way to the defendant's apartment as he claims? Did she get stuck somewhere between there? I mean, you know, 5 miles is only 5 miles, and if the critical distance here is longer than that, this might be a key piece of evidence. The judge says he's inclined to let this in. The device is called a progressive snapshot. It's from that insurance company. So look, this comes in. We've got the Fitbit stuff. Now we've got this data. Is this going to make the case a lot easier for the state?
Absolutely, along with the Google kind of roadmap that they have of where Mr. Burch was on that night from his phone that was triangulated. This snapshot device, earlier, the judge had indicated he was not going to let it in because he felt like they needed an expert from Progressive to come and testify. But this reversal is a big deal for the prosecution's case. It means that they're going to be able to conclusively show through this particular piece of evidence that Nicole Vanderheiden's car never left that house.
Yeah, I mean, if that gets in and we get the proper experts to testify about it, then that's really going to deflate the defendant's story. But, you know, again, I'm back in this arena of why was this not settled long before now? This does not seem like it's some surprise thing, like, whoops, all of a sudden we realized that this device was in the victim's car. You know, why wasn't this settled before now?
There seemed to be, at least from the defense side, they made a statement that we had a lot of time to figure out what we were going to do with the Fitbit data. Why weren't we given the same amount of time to figure out what we're going to do with the snapshot device? So it appears that some point before this came up and the judge said, look, we've got to move forward. I've made a decision. We're not going to linger on this issue. But it looks like he's made a reversal of that previous decision. And I don't know why it wasn't explored more before, but at least from the defense's perspective, there was more time spent on analyzing and presenting the legal arguments and evidence when it came to the Fitbit data than they spent on what was going to happen with the evidence from the snapshot device.
So, you know, they're continuing to go down this road, apparently getting more and more information from this. Another really interesting thing here, it's been promised or suggested, depending on where we are in the process, that the defendant himself is going to testify. And if that occurs, of course, that flips the analysis we were just having about whether or not previous convictions come into play here. Well, we were talking about this previous murder in another state of which the defendant was accused and then acquitted. Okay, well, that doesn't come in because he wasn't convicted of it, whether he testifies or not. But look, oftentimes criminal defendants don't testify because they can be impeached on previous convictions. So you get on the stand, your previous convictions come in. Apparently, the way the judge is going to allow that to go along here in this case is he's going to say, or he will allow questioning, have you committed previous crimes and how many? Apparently, that's going to be the way that that process unravels if the defendant takes the stand.
Absolutely, Aaron. And the interesting thing about that is the prosecution has to live with whatever answer he gives if they don't have any evidence of a previous conviction. If they don't have a previous conviction, he can say, no, I haven't committed any crimes, and there's nothing they can do to refute that because there's no paperwork that says he's been convicted. So even though he was accused, he was found not guilty, the presumption of innocence, you come in innocent until proven guilty. The state never proved him guilty, so that presumption of innocence goes with him through every stage. So he has every right legally and factually to say that he's innocent.
Yeah, really interesting set of circumstances here. Usually when we're analyzing whether or not impeachment testimony is going to come in, it's because somebody has actually been convicted. Of course, I don't know. How many other crimes does this guy have on his record? Does he have other crimes that weren't accused murder cases that could potentially come in?
I mean, if he does, and they're crimes that involve his ability to be truthful, they can come in, even if they're misdemeanors, or if he's been convicted of a felony, those things will come in to prove that, or to show or establish that he is not as credible as his defense team wants him to be. But he has to testify. This case is not going to be able to do much for the defense side if he never takes the stand.
Yeah, this gets very, very complicated, very, very tricky. And of course, we were talking right before we cut back in here, Andell, with just how much of this gets dealt with ahead of time. You're in a state that allows attorneys to depose witnesses before a trial, and that's, one would think, a much more fair way to do things, but it's pretty rare. Not many states allow that, and not every state has what I'm used to, which is called open file discovery. In one state where I'm licensed, the defense basically gets a copy of everything in the prosecutor's file, and that includes everything in the police files. In other states, it can literally be a surprise. It happens right in front of the defense team, and they just have to react to it. So when we examine processes across the various states, it starts to raise questions of fundamental fairness that in Florida, if you get a crack at everything and you get a chance to formulate a defense, and in other states, it's almost a literal, or it is a literal surprise as to exactly what the prosecution is going to get out of some of these witnesses. You know, which state is more fair than the other?
You know, that's a tough question to answer, and it seems that the legislatures of the different states decide how they want to approach the criminal justice process, and the process of what we call discovery is where you get whatever information there is out there. But even in Florida, even though we have depositions in state court, many of the trials that I've had in federal court is more like Wisconsin, where what we call is trial by ambush. You're getting ready to start the trial, and the U.S. attorney just turns over a bunch of stuff and says, here's everything, and you get it, but you don't have a whole lot of time to digest it. You don't have the depositions. So it can even vary whether you're in state court or federal court, what type of discovery process you're going to have.
Yeah, so we've got a lot of evidence in this case. We have a lot of technical data in the case. We've got a lot of DNA evidence in the case. We've got interesting characters on the witness stand. You've got the defendant's DNA all over the victim. He claims that it was consensual sex. The state claims it was part of some sick murder. You know, as you said before, maybe some of this would make sense if we look at it in a vacuum, but then when the defendant starts spinning his story, well, you know, I was present for some of it and the boyfriend forced me to go along with it at gunpoint, and then the boyfriend is up on the stand and he says, I don't have a gun that I can conceal, so how could I have done that? You know, then you get the jury speculating, well, does the boyfriend have another gun? Is he telling the truth? Is he not? I mean, this thing is turned into a mini trial about issues that really don't have to do with proving elements of a crime.
And one of the interesting things, Aaron, is it appears the defense has elicited testimony that actually flies in the face of what their client is going to testify to. Earlier, when they asked a girlfriend about whether he had any injuries, they asked his friend about whether he had any injuries, both of them said no. So it appeared that the defense was pleased with that testimony. Then how do you turn around and say that I was knocked unconscious and I had you didn't have a bruise, you didn't have a scratch, they knocked you out to the point where you don't know what happened, you woke up with a gun in your face and you got to do all this and you don't have any sign of that struggle. I think that's a mistake for the defense's theory.
This is really, really interesting. We're nearing the end of the broadcast day, though, here on Law and Crime. Andell Brown, attorney out of Miami, Florida. Always great. I always appreciate your well-spoken analysis.
Thank you, Aaron.
We are getting ready to wrap the day up here on the Law and Crime Network. A reminder that we're on the air from at least 9 a.m. until at least 5 p.m. Monday through Friday with live coverage of trials across the country. We will see you back here tomorrow. Again, keep in mind the George Burch case. The state is expected to call 2 more witnesses. That was the last word today when the jury went home, and then the state will rest its case. We are waiting to see exactly where the defense goes. Andell just raised some great points about the testimony today. We'll see you back here tomorrow. For now, this is Aaron Keller, and for everybody here at Law and Crime, have a great evening.